There's something about this whole thing, right? There's something about this entire thing that I don't really know the kind of like state of consciousness that most people are in, but there is that focus or clarity or attention that some people just seem to be, not getting through to, where it's almost like, when someone says something and, like you kind of like find, you get a joke in it, or do you get the joke, like when the joke clicks, or even if you get the second or third meaning and it clicks. But you can do this like years after you've heard something, right? And how you break through that is focus and concentration, but also contemplation. So you have to be thinking about it. You have to point your mind onto it, and usually for a certain duration of time as it comes through. But it's you can study it, right? But then if you go to something else and find some other information or an other fact, and then you come back to it, then the other information. So it's not just information within it that you actually draw out of, but also other things that add into it. We've got this. I've been thinking about this, with the diverse and arbitrary and illegal courses and so forth, because you've got the courses of judges that go around the country. That's what they had, the circuits that went all the way back around the country and then to the Tower of London. But then you've also got the courses and different diverse and whimsical ways that people go about petitioning and gathering together, or voicing the free speech, or what diverse and arbitrary whimsical matters people want to petition about. And obviously, you need, for any case, you need evidence, and but there's an entire study you can do into the language and use and employment of the terms arbitrary and diverse ways through all the acts of the contemporary period of this. And now we've got that the Scottish version, the claim of right, but also in the language that people were using in their daily life and so forth, particular people in the government. But so look, I typed in the word here, evil, right? I typed the word evil in the search box, and it only appears once, as far as I think that's one. I think it only appears there. I'm quite certain it only appears once. So, I don't know. The other video that I did, just looking at the layout of the act, the fact that some of the opening parts of the modern acts are actually at the end of this act, like, when it's, be it so enacted, and so forth. And the fact that I put the red spot at the start, because it's definitely really about us and our liberties, although by the time it sets out all these opening bits, which do actually add the context and so forth, when we actually declare our rights, the rights of the subjects, where I've put the pink spot, but the whole act is our rights and liberties, really. You don't just start there. All this first part adds all the context of the matters, standing armies and so forth. Well, if you're petitioning the government lawfully and writing it down and submitting it and gathering evidence and going about things, even getting people to support it and speaking freely, even if not being a little bit rebellious, you haven't got an army. You're allowed to gather peacefully or to protest, but it's not classed and regarded as an army. You've got standing army in here, and you've got the right to bear arms for defence, but you haven't formed an army. You're not attacking, so you're not attacking the government physically with an army. And I think that's important context for why would they give you immunity from prosecution through the courts for going about these officially recognised type of proceeding that is long established before even calling MPs to go and represent you instead. Then you've got a person who can go represent you, and you can call a parliament together rather than everyone just writing it on paper and sending it into the king or putting it through those justices and the Lord of the Articles or whatever. So these liberties that are created for the people, and you know, I would say that the immunity is probably the most important thing in the whole act. You know, and the things that, you know, you can and can't do, like, you know, standing armies and drawing arms unless it's for defence only and so forth. The whole act is for us and our liberties, although you list them here after you've, you know, got your context into, like, you know, what are illegal prosecutions, you know, by courts of the King's Bench and so forth, matters that you're taking to the Parliament or the King. So the thing is, well, what would happen if you didn't have these rights applied? And why are they making these rights and protections to protect you from who? Well, illegal prosecutions can only concern a very small number of people, because you can only be prosecuted illegally or imprisoned illegally, like in this other act, you know, this the Claim of Right Act, 1689, which it words it as imprisonment as well. You can only really be imprisoned when you've had a trial by a judge or it's been brought by a prosecutor. So, you know, we didn't have police force. We had, you know, like the constables, you know, or the high sheriff or whatever it is, right? I didn't really want to say whatever it is, but I know what it is. It's a constable and high sheriff. So, so look, for these rights and liberties, the only career and position that could possibly be of consequence are prosecutors and judges, really, and your ministers when they're meant to be representing us in Parliament and our matters. Because, you know, when we call a Parliament, we're meant to meet them through our surgery and hand them our matters, and they're supposed to debate them. That's the point. You know, Parliament either houses or to the King, right? But surely the elected MP is the replacement of having to write down all these claims and send them into the King, because, you know, we send them to Parliament to debate the matters for us. It's the human, the personified. Surely it's the personified person. Now, right at the start, right, there are our rights and liberties, right? The heads of declaration of Lords and Commons recited. So it's the heads and declarations and Lords of Common recited. This isn't that first section there is just that they're reciting. But what are they reciting? Well, they're setting out what is this whole thing all about and what is the context of it all, right? You know, not just that our rights start there by the pink bit. Our rights don't start by the pink bit. This whole thing's about us and our rights. So as they recite and get into it, right? Right at the start, yeah. We know in our minds that this act is now containing and created a very, very important immunity, right? And protection. And it's not creating petitioning. Petitioning is very, very long established, and they've even had that 1661 Act and other things. This is specifically for the making it protected, right? Who would you need to protect against? The justices or prosecutors, no one else, right? And also your ministers are meant to be responsible for carrying our matters to Parliament as well, and debating the matters if it's not directly to the King or the House of Lords, right? So right at the start here, whereas the late King James II, by the assistance of diverse, that is many, many different types of evil counsellors, judges and ministers. Oh, well, even councillors. Well, you could include local councillors in that as well, not just MPs, but people on the council. that could be local council authority that you petition to, employed by him, well, they're employed by His Majesty's government, or they are. It's when you go to a court, it's got the Royal Arms on it. The staff, government staff, employed by him, did endeavour to subvert and extrapolate the Protestant religion, and more importantly, not just about religious matters, the laws and liberties of this kingdom. Well, that suggests that there were already laws and liberties of this kingdom before this, because we've got the 1661 Act, which in a way kind of subverts it, in a way trying to restrict it. And they were even charging people to do petitions at one point, and a lot of the articles, they were charging them a fee, right? And before the 1661 Act, we know they were still doing it then, and then they were even referring to this natural law or whatever. You've got that old parley, you know, when you have two leaders of an army meeting and they agree not to fight, they agree not to have arms against each other. There's a scene in the Halloween Doctor Who from the last series when she calls parley, and I think they're trying to make a point in that, you know, both the leaders go meet without drawing arms against each other, without attacking each other, to discuss terms. You know, they're about to have a war where they send in full forces of armies and many soldiers, horses, you know, artillery, a lot of money at stake as well. They could kill each other, but they both walk up together and don't attack each other. There's something in that parley, the white flag of two, Party A and Party B coming together. They will not attack each other. There's something in that, in the right to petition, where you're bringing a case and, you know, the government agree not to prosecute you, you know, while you're undertaking these proceedings. I think that the BBC know about that, and that's why they put that in there. And possibly even going way back to, you know, when, you know, like when you can challenge, you know, like if you've got an argument or something, you can challenge them to combat, trial by combat, or that was like one of the natural laws. You know, if you've got a dispute with someone, maybe Party A and Party B fights it out, or they used to be able to nominate someone to represent them, you know, like in the Game of Thrones, like choose your champion who will fight for you. There's something, there is some sort of, it draws from that. It draws from the essence of that principle. If you don't want to fight yourself, you can represent someone, like, you know, you can have a lawyer represent you, you can choose a champion to represent you and fight for you. But obviously we're not fighting in arms. You see, that's, you know, with the armies, it's usually the leaders who go up and talk, but they could send a diplomat. Army A might send a diplomat, a talker, and Army B might send a diplomat or a talker, and even though they're about to, you know, annihilate each other, they don't attack each other, they don't fight, they are there to debate the matter. Maybe it can come to a conclusion without a battle, and if not, then they fight. I think that that is the principle that this has all originated from, and it's highly likely that that is what those people are referring to when they say like a natural right, or for, you know, bringing a grievance or whatever. But sorry, back onto this. I've been 13 minutes now, and I really don't want this video to be half an hour long, because I've made enough videos now really on this. But this is important for the Office of Judicial Investigations, right? This is really important for the Office of Judicial Investigations, because they're always going on about, oh no, you know, if an order's being made or a judgment, we can't do anything about it. We're talking about a judge or prosecutors, whether it's a CPS, doing something wrong, something they're not supposed to do, something they don't have the right to do, something which may be unlawful, yes, even for them. And is this immunity even for them? And in what act, if this is about us and our liberties, then I question what even act theirs is in, because in Magna Carta it only talks about the barons, and it says they can be prosecuted, but only by their equals. It never says any judges can only be prosecuted by their equals, or prosecutors prosecuted by their equals. So this, in fact, this is the first clause, right? So it's talking about evil judges, councillors or ministers, which happens to be the people that we are complaining to most of the time in petitions about the local council doing something with planning permission or building permission or something, or ministers in Parliament, meant to be representing us, but they're not doing what we want them to do, right? Or if we've done something wrong, we get judged by judges, right? But so this opening bit, the last line there in the opening bit, this and the laws and the liberties of the kingdom. Well, this is making new laws and liberties, and it's actually saying that there were some laws and liberties of the kingdom, like when they were petitioning through the 1661 bill, and even earlier, which we've now definitely set out and defined. But this one makes it illegal to be prosecuted, unlawful. That means that someone somewhere is doing something wrong, and it ain't you, right? It's them. And who might them be? Well, it tells you in the opening part. Possibly the king, with the assistance of diverse evil councillors, judges, and ministers, for subverting the laws and liberties of the kingdom. Well, if you're going to court and you're doing an official judicial process, which is a petition to Parliament, which is an official recognised judicial process, and you can't be prosecuted, the only people who you could be prosecuted by are evil judges or prosecutors, right? And if the ministers are not helping you out, like, with the petitions committees or the committees for privileges and so forth, and if they're refusing to debate your matters or hindering them or whatever, not even helping you out with the immunities, subverting them, what is actually happening in these court cases is that they're not recognising the rights, they're not even acknowledging it. In fact, Max Hill, the Director of Prosecutions, Public Prosecutions, was completely ignoring two acts of law, the Town and Country Planning Act and the statutory instruments of the Act, which he should have known about. In fact, every councillor, diverse and evil councillors, judges and ministers, the councillors should know all about those placing advertisements in public and the rights, particularly when they're running for council and using the rights themselves and the enactments, Class E and F. But they don't really need, they're getting lots of funding and sponsorship by their parties. They don't need to paint things in public, although they could make use of that if they had to. If you go back in time to when they're putting OXO adverts on walls or Bovril painted on the side of buildings, we might be able to find some political adverts painted on the buildings or walls from 17 or 1800s. If we look, there might be some political adverts painted on buildings back then. So this opening bit here, this is the act that declares our liberties, and it's saying that in the past we're having to create it because they've been subverted by evil councillors, judges and ministers employed by the king. Well, that's exactly what this issue is. Why would I be complaining to the Judicial Office of Investigations about my rights and liberties being subverted? It's the exact precise department to write to. Oh no, but they made a decision, and this act is specifically for this. This is what it's for. When you're doing a petitioning and you get prosecuted illegally, and they're not meant to do it. Why? Because they're evil. Well, it's a bit of a harsh word. That, in modern terms, naughty, bad, naughty ministers, naughty councillors, naughty judges. And again, why? Well, they don't really want us to have that right. And that was the problem. They didn't really want them to have the right before. They were trying to subvert it in various ways, which we've covered and which Professor Karen Bowie has covered. It's in this opening bit. So if you've been prosecuted, this act says it's illegal, unlawful to be prosecuted or imprisoned or convicted when you're petitioning either of the Houses of Parliament or the King, right? That's what it's meant to be understood as. But who would do such a thing? Well, guess who? So who's naughty then? What is this about? What is it for? Tells you the red spot, the whole thing. And, when we really get into it at the bottom, after we've set it all out why, and what the definitions and parameters are around it, like, we're not really supposed to have armies or draw arms unless it's for defence, and so forth, well, there's clearly some kind of limitations and lines drawn around it all. I would have thought this is it. So if you have, because of the subverting of this right before, this is why it is now created, this immunity. And guess who? There's not much guessing of who is the perpetrator in such circumstances. So what do we do when this is the evil that the judges may not do. This is the evil that the judges may not do. Subvert the laws and liberties of the kingdom, which is illegal prosecutions against the right to petition. What else? I mean, what? I mean, it isn't that much of a long piece of law. You know, red spot is what it's for. Pink spot is when we get. This is not our section here. This is listing it out after we know what we're talking about. You know, this is the context, and this is just as the heads of the Commons recited. So what they're doing is they're reciting. Not about that first section is not any rights of any officials or anything like that. Quite the contrary. They're reciting the whole thing now, getting straight into it. They're merely saying the whole entire thing there. They're just going to recite all of it now. And all this is why? Why dispensing power? Why, committing prelates? Why standing army? And why make prosecutions illegal? Well, and what can and can't you do in petitioning? Well, clearly you can't have a standing army, and clearly you can't draw arms on anyone unless it's for defence. They used to have that. There was a big thing in the duelling in the 1700s. There were a lot of illegal duelling because they believed that if they both drew a pistol on each other at the same time and fired, it was in defence. They were both defending themselves at the same time. When they both draw a pistol and fire, the other person is drawing on them, so they're compelled to defend themselves. So there was some sort of thing about that being a legal loophole to a challenge. And that really goes back to what I was saying before about the ancient law or ancient right, this whole challenge each other to a battle or a duel, or like in Game of Thrones, they can nominate someone to represent them. Now you usually... you have to defend yourself in court, nominate someone to represent you, to defend you. So this is what the Judicial Office of Investigations, I don't really think they fully know what this act is all about. It's all about the Judicial Office of Investigations. It's got Judicial Office of Investigations written all over it. That's the whole point of it. Particularly if they're prosecuting you unlawfully when you're engaging in petitioning, which isn't allowed to be. They're not allowed to. So you do appeal it. It says, they're the naughty one. It's illegal. They are the naughty ones. They've been naughty. It makes it naughty. It's not like, they can do that. You'll have to just appeal it with a different judge. No. Don't do that. You need to have your bottom smacked. With the Judicial Office of Investigations. It's not allowed. This is the point of the act. It's subverting the laws and liberties of the kingdom when you do that, right? This is why we get annoyed with these complaints departments in government who usually are subverting our complaints, even Ofcom. It's all set up now. When complaints departments aren't what they used to be, they're always trying to argue the way out of it. In many cases, even Professor Tim Wilson has said that you've got one department says it's the other department's responsibility, then that department says it's the other department's responsibility, and then you get them both together, and there's no other department it could be. It has to be one of these two because there is anything else remotely connected. And they will both vehemently sit there and say, it's not our responsibility. So whose is it? They're in absolute and complete denial of, and this is why many of us are getting annoyed with the government at the moment. They write the policy and remit almost so it's defeating. It's a defeating remit. It's a defeating policy. It's almost like YouTube now. They're making their policy up so they can. It's very loosely defined, and you know they're taking videos down. You know, Robert F. Kennedy's now suing them for taking his political videos down. But you know that's what I want to get onto next with our public, with the advertising, publishing the campaigns to gather evidence of public support signatures, which is what Parliament tells you to do with petitions. It asks you to publish them on Facebook. It asks you to publish them on Twitter. But it is, I think it is the Office of Judicial Investigations, you know? Well, I don't think it is. I know it is, because that is that is the whole point in this. That is the point in this. Judges aren't supposed to do that, and it could concern nothing else when you have been engaged in activities which are for the purpose of part of petitioning in some form or other, and you've declared it, and it's not deniable. They've done something bad, naughty, and this is why this opens with it. And that is why it's probably the first thing. Why open an act with naughty judges, ministers, and councillors, and then go into the most legendary clauses you can come up with, that happen to be stopping them from prosecuting you, and then say that if they do that, prosecute you, that they're not naughty, or that they could do that, and you have to get another judge to decide. No. That's it. They've done the deed. That's it.